Good evening. At this time, I'd like to call to order the Planning Commission meeting of May 19th, 2025. For viewers watching at home, some members of the public may be participating via video conference or teleconference. Please stand and join me in the Pledge of Allegiance. Thank you. Will the Secretary please call the roll?
Commissioner Ferris? I'm sorry. Commissioner Tyler Kettlehat?
Here.
Commissioner McMahon?
Here.
Commissioner Buss?
Here.
Commissioner Lanson?
Here.
And Chair Ferris.
Here. Tonight we have with us Deputy Community Development Director Fabiola Zelaya-Melliker. Are there any written comments, announcements, or continuances at this time?
Not written comments or anything else to report. Thank you.
Okay, thank you. Now's the time for public comment. At this time, any person may address the commission regarding a city planning matter that is not on this evening's agenda. Should the commission wish to discuss an issue raised by a member of the public, the issue will be referred to staff for scheduling on a future agenda. Anyone who would like to speak under public comments must fill out a speaker card in chambers or click request to speak on the agenda to receive instructions before the public comments portion of the agenda is called. Speakers' remarks should be addressed to the commission as a whole and not to an individual commissioner or staff member. Unless otherwise provided by the commission, speakers are limited to 5 minutes. Screen will show you the remaining time you have. We do have one member for public comments, Ellen Garrett. If you could please come to the podium and state your name and city of residence.
Hello. Thank you for letting me speak tonight. My name is Ellen Garrett. I live in Thousand Oaks. I've owned my home in Thousand Oaks since 1999. I'm speaking this evening about a development that's gone in and is almost ready to be occupied on Old Conejo School Road. And it's the small factory-built housing development with individual units on the lot. I called Steve Kearns last week. Actually, I wrote a letter to the planning department last week, and Steve Kearns very kindly called me and said that he would welcome my making any comments about that development. I'm an architect with over 40 years of experience. I've done residential, commercial, college development, so I'm quite experienced with zoning codes, et cetera. I was alarmed when I saw that development under construction because the construction wasn't going the way projects normally go when you have factory-built housing. So that was question number one. But number two, when I saw the number of units being moved onto that lot, I thought surely something isn't right here, or else I'm not seeing the project in its finished scope and give them a chance. Well, Steve Kearns informed me that that project was under the jurisdiction of the state of California and that the city of Thousand Oaks had absolutely no opportunity to give input on that project. So the city of Thousand Oaks is just as alarmed about the development and the problems with it as I am and a number of other residents are. My son went to Conejo Elementary School when he was a little boy. I think it's especially alarming for parents of children at Conejo. That old trailer, the reason why it falls under the jurisdiction of the state is that it's considered a trailer park. Even though those are factory-built wood homes, they are still considered to be under the jurisdiction of trailer park. The old trailer park used to be a little bit of concern because it was so junky looking when my son was small. This park is of concern for a different reason. If you go on the website for the units, which are interestingly called Lakeside Villas, I guess the lakes is what they're referring to, those units are 510 square feet. They're not low-income housing. For a 510 square foot unit, that is a 1-bedroom unit with a 4-foot counter called a kitchen, and the bedroom is 8 by 9. That isn't allowed in normal residential construction. So those units are 510 square feet. They're being advertised for $2,800 a month rent. And the larger units, which they interestingly call 2-bedroom units, have 2 little 8 by 9 spaces called bedrooms. Those are 15 square feet larger, and those are being advertised for $3,800 a month. There are no front yard setbacks. There are no side yard setbacks. There's no rear yard setbacks, as usually required in residential projects. The parking is extremely restricted. I called the office of the developer on Friday because I thought if I'm going to object, at least they should have a chance to rebut. They were not interested, and they were the person that I spoke to regarding the units was kind of upset that I wanted to speak against it because they're starting to rent them now. So the point of my coming here to speak is Steve Kearns told me that the city had no luck even reaching out to our assembly people or Congress people, which is shocking, just shocking to me that the state would allow something like this to go through. And I know a lot of other parents and neighbors are equally shocked as I am. And is there anything that you're aware of that can stop this project?
Thank you very much for coming before us tonight. Okay, that was all the speakers for public comments. Next, we'll go to the consent calendar for minutes of May 12th, 2025 Planning Commission meeting. Ms. Gore, I believe you have some
Yes,
comments you wanted
I
to
have
bring
some
to attention.
corrections. On page 2, line 8, the line should read that Community Development Technician 2 Gomez presented the report, comma, responded to questions, comma, and clarified, and then the rest of the sentence. And the vote needs to reflect you as chair, Chair Ferris, and replace link with bus. Sorry about that.
No worries. Thank you for bringing that to our attention. Are there any of the fellow commissioners want to comment or make a motion to approve? Commissioner McMahon.
I move that we accept the minutes of Planning Commission meeting May 12th, 2025 as corrected.
Thank you. Any comments? If not, can we schedule a vote?
Commissioner Buss?
Yes.
Commissioner Tyler Kettlehut?
Yes.
Commissioner Lanson?
Yes.
Commissioner McMahon?
Yes.
And Chair Ferris.
Yes.
Motion carries 5-0.
All right, thank you. Next, we'll go to public hearings. We'll open the public, if we could please open the public hearing for case 7A.
Hearing having been advertised as required by law is hereby open to consider Agenda Item 7A, Municipal Code Amendment MCA 2023-70010 to amend the Thousand Oaks Municipal Code relating to the regulation of urban lot splits and 2-unit housing developments, SB 9 units, by updating Title 9, Chapter 4, Article 37, Sections 9-4.3703, Definition of Terms, 9-4.3704, Eligibility, 9-4.3705, Urban Lot Split, Planning Permit and Application Requirements, 9-4.3706, Urban Lot Split Standards and Requirements, 9-4.3703, 2-Unit Housing Development Planning Permit and Application Requirements, and 9-4.3708, 2-Unit Housing Development Standards and Requirements to implement recently adopted state law, and find that the update of the city's SB 9 regulations is exempt from the requirements of the California Environmental Quality Act, CEQA, pursuant to California's Government Code Sections 65852.21K and 66411.7N, which specifically find that ordinances adopted to implement the provisions of Section 65852.21 related to the regulation of 2-unit housing developments, or 66411.7, 411.7 related to the regulation of urban lot split shall not be considered a project under Division 13, commencing with Section 21000 of the Public Resources Code, and recommend the City Council adopt the ordinance to comply with state law. Located citywide, the applicant is the City of Thousand Oaks.
Okay, thank you. Presenting on behalf of staff is Senior Planner Justine Kendall.
Thank you and good evening. As just mentioned, the request for this item includes MCA 2023-70010, which includes updated regulations and standards for the local implementation of state laws SB 9 and SB 450. The Planning Commission's role for this item is to review, hold a hearing, and make a recommendation to City Council. City Council will take the final action on the proposed municipal code amendment. Staff's request this evening and recommendation is to find that this municipal code amendment is exempt from the provisions of the California Environmental Quality Act, or CEQA, as directed by state law, and to recommend that City Council amend the Thousand Oaks Municipal Code by modifying Title IX, Chapter 4, Article 37, to update the city's zoning regulations to implement new state law and improve the overall functionality of the ordinance. As a brief reminder, SB 9, also known as the California Housing Opportunity and More Efficiency Act, or HOME Act, was part of the state Senate's Building Opportunities for All housing package created to address the severe housing shortage in California. SB 9 was signed by Governor Newsom on September 16, 2021, and the law went into effect on January 1, 2022. The Thousand Oaks City Council adopted MCA 2022-70465, implementing SB 9 state law on October 11, 2022. SB 9 applies to all single-family residential zoned properties within an urbanized area, such as the City of Thousand Oaks, with some exceptions, and requires ministerial approval of the following project types: a 2-unit housing development, which allows up to 2 homes on an eligible single-family residential parcel, not including permissible accessory dwelling units, or ADUs, and an urban lot split, a one-time subdivision of an existing single-family residential parcel into 2 parcels of roughly equal size. Projects processed pursuant to SB 9 allow for a total of up to 4 residential units, including ADUs, within the original property boundary of an eligible single-family residential parcel. As ministerial approval is required, jurisdictions may not apply subjective or other discretionary approval processes and may not have hearings for projects that meet the state rules. In September 2024, Governor Newsom signed SB 450, which took effect on January 1, 2025. Under SB 450, the city must allow the demolition of more than 25% of the existing exterior structural walls for certain unit types, may no longer impose standards on 2-unit development projects that do not apply uniformly to development within the underlying zone, unless the standards are more permissive, must approve or deny a completed application for an urban lot split or 2-unit housing development project within 60 days, may no longer deny an application for an urban lot split or 2-unit housing development project due to specific adverse impacts to the physical environment. However, the city may still deny an SB 9 related application for adverse impacts on public health and safety. And lastly, the city may only impose standards on urban lot splits that are related to the design or to improvements of a parcel. This last one, it should be noted that the city's existing ordinance already complied with that requirement. SB 9 outlined how jurisdictions may regulate SB 9 projects through objective zoning, subdivision, and design standards, as long as such standards did not preclude the construction of up to 2 non-ADU dwelling units of at least 800 square feet per eligible lot. So while SB 9 requires applicants and cities to comply with certain provisions, such as maximum parking space requirements and setbacks, it also provided cities with some flexibility to implement local objective standards. However, SB 450 further restricts that flexibility to say that cities may only apply objective standards that uniformly apply to the underlying zone. Happily, the standards in the existing ordinance were drafted with an effort to maintain consistency with the required design and development normally required within single-family residential zones, and only a few standards in the existing ordinance required either removal or adjustment. The proposed municipal code update would ensure that the city's process requirements and development standards are consistent with current state law, while retaining as much local control as possible. Furthermore, since the adoption of the original SB 9 ordinance in 2022, some opportunities for clarity, correction, and consistency have been made apparent. The proposed changes to the existing SB 9 regulations found in Article 37 of the Thousand Oaks Municipal Code can be summarized as falling within the following categories. Changes due to the amendments to state law enacted by SB 450, changes to otherwise bring the ordinance into compliance with existing state law, changes made to improve readability, changes to adjust a numbering or internal references, changes to correct typographical, grammatical, or spelling errors, changes to improve consistency between sections, and changes to clarify the process required for review of SB 9 related applications. I will review some of the specifics of more substantial changes right now. Some efforts to clarify the existing project review process are included in the amendment. First, to determine eligibility for an SB 9 project, an urban lot split, or a 2-unit housing development, a complete application must confirm that there are no protected habitats or trees in the project area. Previously, different types of professionals had to provide these statements, causing excessive applicant confusion and expense. The amended ordinance now allows the same types of professionals to submit one or both necessary confirmations. Secondly, a habitable dwelling unit must exist on the property by the time a new urban lot split or 2-unit housing development is approved in order for the applicant to meet owner occupancy requirements. In instances where both application types have been submitted, the amended ordinance now clarifies that a building permit shall not be issued for a 2-unit housing development until the urban lot split tentative parcel map is recorded, unless the arrangement of units approved under the 2-unit housing development is permissible without the urban lot split. This is not a change in procedure, merely a clarification for ease of use. And lastly, the processing times required by state law have also been incorporated into the ordinance, and expiration periods have been made consistent between project types. As described earlier, SB 450 requires all objective standards applied to these projects to be only those that already apply uniformly to the underlying zone of the subject property. This requirement has resulted in several of the changes in the amended ordinance, including those standards related to architectural design. Otherwise, standards related to height, hillside, and ridgeline performance standards, restrictions related to grading on steep slopes and protected trees, owner occupancy requirements, setbacks, and the required number of parking spaces remain effectively the same. In some instances, wording changes have been incorporated for clarity, to improve consistency between sections, or to address existing errors noticed since the original adoption of Article 37. For example, the standard related to maximum height is effectively remaining the same. The amendment addresses an error in the existing ordinance, which incorrectly stated that structures could be up to 25 feet but had to remain at only 1 story. The language should have stated structures could be up to 25 feet and could be no more than 2 stories, and has been interpreted in this way since adoption. As an example of an area where the language has been adjusted to be consistent with existing standards within the Thousand Oaks Municipal Code, the requirements for pedestrian access have been updated with the same language found in Article 22, Objective Design Standards, which is applied uniformly to zones underlying eligible SB 9 properties. Similarly, the standards currently within Article 37 related to garage conversion design and privacy glass do not apply uniformly to any underlying zone. So, in compliance with SB 450, that language is to be removed. However, additional objective design standard language found in Article 22, Objective Design Standards, have been added, specifically those related to garage size and entry cover requirements. Pursuant to SB 9, if a dwelling unit on the site has been rented in the past 3 years, no demolition of that unit which has been rented is allowed. Previously, if there were other units that were not rented but on the same site as a rental unit, only up to 25% of the existing exterior walls of the non-rental unit were allowed to be demolished. Per SB 450, a dwelling unit on the site that has not been rented in the last 3 years is allowed to be completely demolished. The ordinance has been updated accordingly. A flag lot is one located substantially behind another lot with a long segment extending along one side of the front lot to connect the rear lot to the street, as seen in the middle rectangle on this slide. The existing ordinance prohibits flag lots and instead requires an access easement over the front property's driveway, as seen in the rightmost example, in order to maintain just one curb cut for those homes. However, as shared access easements present a significant opportunity for homeowner conflict and code enforcement issues, and the State Subdivision Map Act does allow the creation of flag lots, the new ordinance now requires the reverse. A lot created through the urban lot split process must either allow access from the street directly, through a split shown in the leftmost example, or for instance by splitting a corner lot, or by creating a flag lot. The staff of the flag may not be less than 20 feet wide, which may present challenges to some considering an urban lot split in the future. Lastly, language has been clarified so that just one unit could be proposed on a vacant lot in order to comply with existing state law. In conclusion, the amendment is consistent with the city's general plan, including the 2021 to 2029 housing element. Specifically, Goal LU-3 advocates for diverse housing types and housing for different life stages and incomes. The construction of 2-unit housing development units and processing of urban lot splits supports the availability of smaller and potentially more affordable housing for all age groups and low and middle income families. Staff recommends that the Planning Commission find this amendment exempt from CEQA and recommend that the City Council approve the amendments to Article 37 of Chapter 4 of Title 9 of the Thousand Oaks Municipal Code as described in the ordinance included in today's agenda packet. Thank you. I am available for any questions.
Thank you very much. Are there any questions or comments of staff? Commissioner Lanson.
Thank you, Chair. Just a brief question, and thanks, Ms. Kendall, for your report and going through everything. I know I'm asking you to speculate, but do you think this is the last time we'll have to end up updating this? Do you think they've got it all now where we won't have to keep going back and doing this over and over again?
I expect to be before you again. Yes.
Thank you, but no thank you. One last question. How many actual permits, applications have been submitted to the city under SB 9?
We've had about 20 actual submittals. About 11 have been approved, and I want to say that 5 have been constructed.
Okay, so at least something is happening in that regard. Thank you.
Thanks. Any other questions from commissioners? Commissioner McMahon.
Okay, so there was something in the report about a 2-unit housing development with 1 unit. Can you explain to me why they would call it a 2-unit housing development if they're only putting 1 unit on there?
I mean, I think traditionally the expectation was that the developments under SB 9 would be of the 2-unit variety. But if you look at the text of state law, it says no more than 2 units. So it allows for a 1-unit development. And that's also how HCD interprets the statute also.
Okay, one more question. The owner occupancy requirements, I think, was 3 years. Are there any teeth in that ordinance? Is there going to be follow-up? Is there going to be a penalty if the owner moves away in 1.5 years?
I mean, there are enforcement mechanisms, but to be honest, like, it's very unlikely that will be enforced because the time frame of the enforcement is from approval. So by the time you construct it, something happens, you're pretty much at 3 years.
Gotcha. That makes sense. Thank you. That's all.
Thank you. I did have just questions related to sort of urban lot split. In looking at SB 50, it looked like there was a couple sections which sort of indicated you can only do this once. Like if you take your lot, you split it, and it's sort of painted with a no, you did this before, so they can't come in and split it again, right? And for much of the city ordinances the ordinances that we have, the language we use to kind of align it with 50 and with 9 and 450 are pretty exact. But I think the sections we have are a little bit different than what's exactly in the state law. Are we comfortable that what we have in our ordinance aligns with what state law prohibits as doing this more than once?
I'd have to know exactly which areas you were noticing differences, but short answer, yes. This ordinance as drafted is, to our best estimation, in compliance with state law.
Okay, perfect. That's all I really wanted to know. Part of that deals with, you can't, if you own the property, you can't split it more than once. But if you own a property adjacent or you work acting in concert with someone, can you explain the adjacentness, acting in concert aspect of this? I think it makes pretty clear, like if you own the property, you can't do it more than once. Is there a kind of an understanding for me about what they wanted to do about preventing the neighboring parcel and what acting in concert kind of means in this context? Sorry, I didn't.
No, that's fine. Yeah, I mean, I think the intent was to prohibit, an entire neighborhood getting split up by like a single developer, right? So if you own your property and you split it, that's okay. But if you start buying up surrounding neighborhoods and you're now splitting those up, or you have an agreement with a developer or something to do lot splits, then that would be acting in concert and that would be prohibited.
Perfect, thank you. I appreciate that, that's helpful. Any questions from other commissioners? Okay, if not, do we have anyone from public comments on this particular item?
No, we do not.
Okay, then we'll go back to staff for any follow-up comments from our questions.
I don't think so.
Okay, perfect. Any questions of staff? Okay, if not, I'll go ahead and close the public hearing. And are there any comments or a motion that anyone wants to make? Commissioner Lanson.
Thank you, Chair. I'm glad we're updating our code. I'm disheartened to know that we're going to be maybe here again, but I will go ahead and make the motion. To find that the update of the city's SB 9 regulations is exempt from the requirements of the California Environmental Quality Act pursuant to California Government Code Sections 65852.21K and 66411.7N, which specifically find that the ordinance is adopted to implement the provisions of Section 65852.21, which is related to the regulation of two-unit housing developments, or 66411.7, related to the regulation of urban lot splits, shall be considered a project under Division 13, commencing with Section 21,000 of the Public Resources Code, and 2, recommend that the City Council adopt the updated ordinance in order to comply with state law.
Can I just ask if it will be a motion to adopt the resolution based on the findings to the effect that you've?
Absolutely, yes.
Perfect.
I read the other part, but forgot that initial part, so yes.
Someone's going to catch it on us anyway. Any comments on the motion? The only comment I have is I read through the state laws and I'm finding that, and this is probably something that would be good for our public speaker to know as well. We didn't speak directly to it. Sacramento and the state legislature are making it very challenging for us to use any discretion for how we go about our developments, and we're finding that more requirements and less discretion is being allowed, so that we have to kind of update our codes and make sure that they're there. I personally find them a frustration, but I also, the counterbalance is if we try to fight that, they end up going to court and getting their way on some of these things, so we have to figure out the right balance of meeting state mandates, but still giving ourselves as much discretion as possible. So, like I said, the direction of this is challenging, but for that reason, I'll support the motion. Any other comments from the commission? If not, we schedule a vote.
Commissioner Bass?
Yes.
Commissioner Tyler Kettlehut?
Yes.
Commissioner Lanson?
Yes.
Commissioner McMahon?
Yes.
Chair Ferris?
Yes.
Motion carries 5-0.
There's no appeal period for this, as this is a recommendation of the Planning Commission to the council. So thank you to staff and those part of the case today.
Chair, before you go to the next matter, I unfortunately have to leave for a plane, so I'm going to leave at this point, but I wanted to make sure to let you know.
Perfect, thank you. Safe travels. Okay, next is case 8A. Tonight we have policies and procedures for conducting public hearings for mobile home rent adjustment, just and reasonable return applications. Presenting on behalf of staff is Community Development Analyst Lynn Oshita.
Good evening, Planning Commissioners. Tonight's presentation is on the city's mobile home rent stabilization program, which is codified in Municipal Code as Title V, Chapter 25, and provided to you as attachment number 1 to the staff report. We will briefly go over the Planning Commission's roles and responsibilities to this program, and then we will discuss the proposed resolution on public hearing policies for just and reasonable return applications. All 8 mobile home parks in the city are regulated by the Rent Stabilization Program. For this presentation, reference to the applicant shall mean the mobile home park owner, and reference to the tenant shall mean the mobile home coach owner renting the space under the mobile home. The program started in 1980 and received various ordinance amendments to codify, extend, and modify the program for both apartment units and mobile home park spaces. The main reason we are here tonight is that with the last amendment in 2021, the City Council dissolved the Rent Adjustment Commission and delegated the responsibilities to hear the just and reasonable return rent adjustment cases to the Planning Commission. The program has 13 subsections in the municipal code. The first 5 sections focus on the background and purpose of the program, its useful definitions, and how the program is applied in Thousand Oaks, the responsibilities of the Planning Commission, and record keeping of the rents by the park owner. The section listed in the middle column are the various ways the space rent can be increased. The park is allowed to increase the mobile home space rent once a year for the tenant, which is 100% of the CPI applied to the base year rent. If a new tenant enters the park, a space is considered a vacancy decontrol recontrol, which means a tenant coming into the park will have a new base rent and a new base year. There are 2 types of rent adjustment applications a park owner can apply for. A capital improvement application is reviewed administratively by city staff, whereas an application for just and reasonable return will have a Planning Commission public hearing. The remaining sections in the code are not implemented by the Planning Commissioner. The next couple of slides will be focused on the policy and procedures for a just and reasonable return application. The applicant is responsible for providing evidence and justifying the requested rent adjustment. As provided for in state law, requests for rent increases are based on many factors, including, but not limited to, property taxes, operating expenses, common area repairs, and level of housing services. After a public hearing, a written determination is made by the Planning Commission. Decisions of the Planning Commission can be appealed to City Council. The responsibilities of the Commission for the Rent Stabilization Program are found in subsection 4 of the Municipal Code. The Commission can issue decisions, pass resolutions, establish policies, request studies, and conduct hearings related to the program. As authorized by City Council, the main purpose of the proposed resolution is to set basic hearing policies to ensure a hearing is run in an open, responsive, and effective manner. City staff recommends a standard time of no more than 15 minutes for the applicant group, which includes their attorneys and consultants, and 15 minutes to the tenant group, which includes the mobile home owners, their attorneys, and consultants, and then a 10-minute rebuttal for the applicant. The proposed resolution also provides options to extend or reduce the time for questioning and cross-examination based upon the facts and circumstances of each case. Staff recommends that the Planning Commission find that the action is not a project under CEQA and adopt the proposed resolution with one additional change to the resolution to further clarify that Section 7, this includes adding relevant to the case at the end of the first sentence and revising the second sentence to start with factors considered may include but not are limited to. This concludes the presentation. Thank you.
Okay, thank you. Before you go, I just wanted to get clarification on those two changes. One was for, what was the first one again?
So the first one was to include at the end of the first sentence of Section 7,
Okay,
relevant to the case. And then the second change is to revise the second sentence to start with, factors considered may include but are not limited to.
perfect. Thank you very much. Are there any questions of the Commission of Staff? Okay. If not, do we have any members of the public who want to speak?
No.
Great. We'll go back to staff. Do you have any rebuttal or additional comments? Commissioners, do you have any questions? Do you have anything?
I just will say that, first of all, we certainly appreciate the Planning Commission's job in this when we have such a application before you. They are very challenging. I think we all understand that you're going to have a lot of passion and testimony from both sides of the table, if you will. Again, the city is in the middle as the independent body that's going to review the application and have consultants to review and present you information to help you and guide you with making decisions. Again, we appreciate this it can be a very complicated process. I'm very happy that all of you here are going to be tasked with that. And I say that just because it takes a lot of work and it takes a lot of effort to review and understand the testimony. And I think you guys have the capability, certainly, to properly evaluate and prepare a decision. And again, as Ms. Oshita stated, in the past we've had decisions that were given by the body that was hearing this matter, and they were both of them were appealed, so that could happen. But at the end of the day, you initially are making a decision based on the evidence and testimony that you receive. So thank you for that.
Great, thank you. Any additional comments from the Commission? If not, there's a motion on the floor. Commissioner McMahon.
I move that we find this action is not a project as defined under the California Environmental Quality Act pursuant to Section 15378B5 and adopt a resolution setting policies and procedures for conducting public hearings for mobile home rent adjustment, just and reasonable return applications. And do I need to add as corrected? As corrected.
Thank you. Any comments to the motion? If not, let's call a vote.
Commissioner Buss?
Yes.
Commissioner Tyler Kettlehut?
Yes.
Commissioner McMahon?
Yes.
Chair Ferris?
Yes.
Motion carries 4-0, Commissioner Lanson absent.
Perfect. Thank you very much. Now's the time for commission comments and/or any AB 1234 reports. Are there any comments from the commission? If not, Ms. Zelaya Meliker, are there any follow-up items, announcements, or upcoming issues?
Thank you, Chair. Tomorrow evening, there will be a Building Month proclamation presentation at City Council and an APA award for the General Plan 2045. On June 10th, there's a telecom law firm contract on the consent calendar. On June 24th, there will be a public hearing on the SB 9 ordinance, which you just considered this evening, and a study session on the comprehensive zoning code update, study session number 1, findings and recommendations. Items scheduled on the upcoming Planning Commission schedule include on June 9th, there will be a department report on the comprehensive zoning code update, study session number 1, findings and recommendations on the technical memorandum and code audit. On June 23rd, public hearing will be held for the Conejo Summit project, 15 industrial buildings, roadways, parking, infrastructure, and landscaping on approximately 50 acres, generally located at the intersection of Conejo Center Drive and Rancho Conejo Boulevard, and a public hearing to establish a new drive-through restaurant use within an existing building at 400 North Moore Park Road. And that is all we have in the upcoming schedule. Thank you.
Great, thank you all. We'll now adjourn to the next meeting, June 9th, 2025 at 6 p.m. Thank you.